The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. Good afternoon. I'm Anna Hobson, and I am a part of the marketing team here at the American Chamber of Commerce Resources, as well as HR Simple. We would like to welcome you to today's webinar, Employee Documentation. It will be about 60 minutes long, and at the end, we will provide SHRM and HRCI codes. Those will be put up on the screen for you. If you do have any questions, there's a question area in the chat box, and I will be able to read those off to Emily at the end of the webinar. If you need to go over the webinar again, it will be posted to our YouTube page, which is under the name HR Simple. Our presenter today is Emily from Frederickson, and Frederickson is a law firm that authors our model policies and forms for Iowa employers. The manual is written by top attorneys such as Emily. Emily defends employers against allegations of sex discrimination, age discrimination, race discrimination, FMLA and ADA violations, wrongful termination and violation of public policy, and tortious interference. To help employers maintain a productive workplace and avoid litigation, Emily partners with clients to provide supervisor and manager training, investigate internal discrimination complaints, provide reasonable accommodations to disabled employees, and navigate issues surrounding family and medical leave. So before I pass this over to Emily, I just wanted to thank everyone for coming out and learning with us today.
Okay, I think I have, my screen should be showing. Did that work out, Anna?
Yes, it looks great.
Okay, excellent. Well, thank you for that introduction, Anna. It's great to have the opportunity to talk to this group. I realize this may be a varied audience. Some of you may have a great deal of HR experience and others may be relatively new and even have responsibilities other than HR as part of your job duties. So if you are already well versed on this topic, perhaps this will help you add some variety to training and discussions with managers. If you're new to the field, I'm hoping this will provide you with some helpful perspective on the importance of documenting performance and discipline issues. We are going to cover the 4 basic rules of discipline documentation and then analyze some examples. Now, a caveat about the rules. We all know this is more of an art than a science. So before you tackle a disciplinary process or advise a manager on how to approach it, you have to make sure all the pieces are in place. This is often a case-by-case analysis. So first, we want to know, has the manager communicated his or her expectations to the employee? Are the expectations within the employee's duties in the job description? Are those expectations reasonable? Are there extenuating circumstances that should be considered? And are there legal risks to be considered, such as pending or recent requests for medical leave, disability accommodations, complaints or investigations of discrimination or harassment? I mention this because every once in a while we find out that it is the manager, not the employee, who needs some coaching. And it is far better to explore those issues before issuing discipline than discovering them after the discipline has been given. So assuming that all of those issues are squared away, we're ready to move forward. And these are the rules. Rule number 1 is do it. When it comes to employee discipline documentation, do it right away. Now is the time, not later, not after lunch, not tomorrow morning, not Friday. Do it now. Rule number 2 is know your audience. Who might read this and why? Rule number 3 is to follow the rules, not these 4 rules, but your own policies internally. And rule number 4, tell the story. Your discipline documentation needs to be complete, correct, and error-free. So let's look at the first rule, do it. If you are the one who needs to document the discipline, I recommend that you find a way that works for you, that you will use consistently. Some of you may have electronic personnel file systems that you must use and you have no choice. But if you do have a choice and you have trouble finding time, I recommend sending yourself an email with the key details. And this is if you have a conversation with an employee. This is not if you've made the documentation and you've sat down to deliver discipline. This is if you have a more casual conversation, you need to document it for moving forward when you do need to do the more formal. But I like this method of sending an email to yourself because it automatically records who wrote it and when, and you can easily drag it into an electronic file or folder, or if necessary, forward it to other participants for review. I do not recommend handwritten notes because they are easily lost and they may be hard to read by you or other people later on. Nor do I recommend varying your methods of documentation. It is hard enough to find things sometimes, and it's even harder if you're not sure whether you're looking for an email, an old legal pad, a Word file, or a tape recording. You know, some managers really prefer to keep things low key. They want to have a conversation. They want to trust that things will work out. But there are big drawbacks to this. First, the disciplinary conversation will inevitably be watered down. I am from Iowa, so we blame it on Midwestern niceness around here. But the fact is that supervisors are not so good at getting to the point, and sometimes they do better in writing than face-to-face. And unlike oral discipline, the written documentation will not end with, but don't worry about it, or it's not like you would ever get fired for this or anything, which unfortunately is commonly the way those verbal conversations end. Also, memory is not perfect. Either the supervisor will remember the conversation differently than the employee remembers it, or the employee will have no memory of it at all. I am a litigator, so I often depose former employees who were discharged for performance issues. If there is no documentation of a conversation about work performance, the former employee often says he or she does not recall the conversation, and we have nothing but one person's word against another's. And that is a dispute of fact that can mean we have to go to trial instead of winning summary judgment. So why not rely on oral discipline? It is watered down. The supervisor will always remember it differently than the employee, or the employee does not remember it at all. And if we do have to, and if we do have to go to trial, the lack of documentation makes it very difficult to convince a jury. Juries expect employers to have records. They are looking for a way to be on the employee's side. They're usually not looking for a way to be on our side. And they will hold it against you if your records are poor or non-existent. I don't think that's fair, but I do think they have a point. If it was important enough to put someone's job at risk, it should be important enough to write down and keep. So I'm using Iowa as my hometown example here, but this applies in many states. Some managers will say they do not need a reason to discharge an employee, and they have the right to fire someone for no reason at all if he or she is an at-will employee. Now, those things are true, but the employee then has the right to claim the discipline or the discharge was unfair, or it was based upon a protected class or a protected characteristic. It is far better to have a contemporaneous record of reasoned disciplinary action when you are defending the company's actions and your actions. It is also useful because it keeps everyone on the same page as to the real reason for the discipline or discharge if they have to recollect the situation months or even years later. Some myths that people cite when they do not document discipline. These fall into the category of, if we ignore it, maybe it will go away. First, they say, well, the employee already knows. She knows she is not doing well. He has to know that was poor work product. And the second goes hand in hand with the first. The employee knows this isn't working out and is probably going to leave. These are really just creative ways of putting off the task of discipline and documentation. So don't let your organization fall into these traps. And then we have the wishful thinking myths. And I do have a retort for each. So forgive me for being a little bit flip here. But if the manager says this employee would never sue, you can say, but would this employee like the idea of getting $1 million? If the manager says there is no way a jury would ever believe this employee, you can say, do you think they could learn to be more believable for $1 million? If the manager says it's obvious we had good reasons to fire the employee, you can say, do you think he would say you had bad reasons for $1 million? And if the manager says, I'll always remember why I terminated the employee, you can say, do you think the employee would claim her memory is better? You got it, for $1 million. So certainly most cases do not result in the former employee taking home $1 million, but the possibility of such a windfall changes the calculation if we are trying to predict someone's behavior. And I think those of you in human resources really have the ability to add tremendous value to an organization by making managers think more critically. And sometimes that means shocking managers out of complacency by reminding them that the calculus is going to change for this employee if something goes badly, and if they get in contact with a plaintiff's attorney who can convince them that they might have a big windfall here. So I'm not necessarily suggesting that you always give the $1 million example, but I do think it can be effective in making people realize that we're kind of in a different world here. There are also some less pessimistic reasons to create and maintain good documentation. When tough performance conversations occur and the documentation lays out expectations for moving forward, the employee has an opportunity to review the documentation, go back to it as necessary, and is provided with a meaningful chance to improve. And if the employee does not improve, at least the expectations were clear. The bad news of getting discipline or being discharged from a job, it's always going to be bad news. But bad news that is surprising is even worse. There is a lot to be said for reducing the surprise. Good documentation decreases litigation, and it improves the opportunity to have a successful defense if litigation does occur. And documentation is evidence. It is the best evidence of what actually happened and the reason why it happened. So let's go to rule number 2, which is know your audience. We're going to talk about your primary audience and your secondary audience. So first, your primary audience is pretty obviously the employee. Here, the documentation serves as the communication. And to be effective, the documentation needs to clearly describe the specifics of the problem, the importance, the gravity, the seriousness of the problem. This is a big deal. It also needs to include expectations. These are the expectations that, if met, can resolve the problem. You want to clearly state to the employee how they can fix this problem by meeting expectations. And then the consequences. What happens if this problem is not fixed? And then my last bullet here is give employee the document. You need to hand it over. This is not a secret. If the documentation is clear and it's fair, you should have no problem handing it over to the employee. The employee needs to be able to review the documentation on his or her own when things calm down, when he or she is ready to think about it, take it in, decide if they're going to respond or how they're going to react. I really think this is the key slide in this presentation. If disciplinary documentation does not contain all of these elements, it is probably not going to be very effective. And I would suggest using some variation of this when training supervisors, and then using it as a checklist before presenting discipline. The secondary audiences are the employee's lawyer, the EEOC or the state or local civil rights agencies. It may be the agency that handles unemployment claims. If things go further, it could be the judge or the jury. And I would also include here, it's very possible that your secondary audience here is the employee's significant other, maybe the employee's mom. I'm sure in HR, if you haven't experienced it yourself, you may have heard some stories about parents getting involved in the workplace. So I don't want you to worry too much about what mom might think about the disciplinary documentation, but I think it's always good to be aware that parents may get involved. And let's not forget the employees' Facebook friends. We live in a different world, and these days when people feel self-righteous anger, when they feel like they've been wronged, they go to social media. And this is yet another reason to carefully draft fair and substantiated disciplinary documentation, because the secondary audience is not something we have control over. The secondary audience needs an effective description of the issue and why it is to improve. And to reiterate, you're giving the employee the document and they may share it from there. So let's go to rule number 3, which is to follow the rules. So as I said at the beginning, I'm not talking about my 4 rules, but I'm talking about the rules that you have do take a different action. And because employees often are not exercising a huge amount of discretion about what they share with coworkers, they're talking more and more about what happens, and they have a right to do that. They may immediately say, well, this thing happened 3 weeks ago with Donna on the other side of the line, and that's not what happened to her. So then you have to, of course, say, well, we can't talk about anybody else's situation, but you still need to have the confidence that your practices are consistent and substantiated and well-reasoned. So check your handbooks, relevant policies, the CBA, and your records of what was done in previous similar situations. And I touched on this at the beginning, and I probably couldn't help myself from touching on it since then, but it is worth repeating. You don't want to go in blind. Look at the underlying facts about the employee. Is absenteeism a problem, or is this job protected leave or an accommodation? And this becomes more difficult the larger your organization is, because the accommodations department may be very different from the leave department, may be very different from the employee relations consultants who handle complaints of discrimination or harassment. So sometimes it takes a little looking and a little bit of probing with the manager about this employee and what the true situation is. Is there protected activity that warrants extra caution when drafting the discipline? And is this a long-term employee with years of stellar performance? I'm not saying that any performance issues should be or that we want to ignore those issues, but there are things that might warrant extra caution. Because when you have the background of knowing that an employee just returned from FMLA leave, you're going to be extra careful about parsing the writing. You're going to make sure to separate the issue, even saying specifically, we are not evaluating performance based on we're not expecting that there was work done during that period of leave, for example, just making it very clear in the documentation that that is not a part of this. And then you want to make sure you have those additional conversations with the supervisor to make sure that performance issues are not getting mixed up with protected leave or protected activity. I'm of the mind that when an employee has taken job protected leave or is requesting it, or if they're involved in protected activity, that is absolutely a case where human resources needs to be involved, not only in disciplinary documentation and practices, but also in just the annual performance evaluation to make sure that the supervisor doesn't accidentally step in a mud puddle and make a big mistake. Because those are the cases where the background of a human resources professional is really important in making sure that the correct words are used and that a performance conversation and any issues with accommodation or protected activity, they're in separate lanes and they're not, they need to not be mixed up. Okay, so we are finally to rule number 4, which is to tell the story. The documentation of discipline needs to clearly tell the story of what has happened. It needs to educate the employee and educate and persuade those secondary audiences that we talked about. And that can only happen if both you and the manager have a full picture of the facts, have a full picture of any potential mitigating factors, and a true commitment to fairness and getting the facts out there. I think that depending on how the hierarchy of your organization is and who holds the power, this can be very difficult to do. And it involves a lot of kind of laying the groundwork with supervisors, making sure that they understand how this needs to work. I see quite often where the managers hold a lot of power in an organization where they will think it is perfectly okay to come to human resources and say, I need to do a performance improvement plan or a warning for this employee, and depending on the types of people you work with, they're pretty adamant this needs to happen right away. I'm not going to put up with this anymore. And then as you probe a little further, you may find out that, well, the expectations were never set forth clearly. This employee has not ever been told that the manager is dissatisfied at all with his or her performance. And this is where sometimes you have to be the person who makes everyone take a step back and evaluate whether you want to take action that could be construed as adverse action against the employee, whether it's a performance improvement plan or formal disciplinary documentation. So be factual. Don't exaggerate. Avoid adjectives or adverbs, and avoid vague or conclusory labels like bad attitude or not a team player. Documentation of discipline is not a place to be a creative writer. This is not a place to have, funny, fresh turns of phrase, to exaggerate a situation, to show emotion, or use any ambiguous language. It is usually good to eliminate the words very and really and extremely when you are going through disciplinary documentation. And similar words like that. You really want to stick to the facts. And the problem with these vague or conclusory labels like bad attitude is that they really do nothing to help the situation. It labels the person, it doesn't label the behavior, and it indicates that the die is really cast. The employer has already made the decision. This is someone with a bad attitude. This is someone who is not a team player. It's not helpful. Later, you could find too that the employee says that this really provoked additional bad behavior, really turned the employee against, polarized the situation. It promotes litigation, and in really bad situations, they may claim that they're being defamed by being essentially called a name. So these are things that have to be avoided in disciplinary documentation. I think it's really important to have, if you can, if your organization's large enough that somebody else is in that circle of confidentiality, find someone who's not involved in the situation, who can read through the documentation to make sure that it tells a very clear story. So an objective reader can catch things that just might come across in an unintended way. So these are kind of for comic relief, but I'm sure we have all seen head scratchers like these in disciplinary reports and in descriptions. So the first one is minors refuse to work after death. New obesity study looks for larger test group. Children make nutritious snacks. Criminals get 9 months in violin case. Police begin campaign to run down jaywalkers. And these are really obvious examples, that things that we wouldn't want to write down because they can be misconstrued. But there are all kinds of things that get into disciplinary documentation that ends up being really not helpful. And it's great to have someone objective, someone who isn't involved in the supervisory relationship, take a look at it and make sure that it makes sense. I had a recent situation where an employee had been on FMLA leave, and when the supervisor did disciplinary documentation, she accidentally referenced the time when the employee had been on leave. And this immediately led the employee to believe that she was being disciplined for work she missed during that time, which was not the case. But it takes a long time then to unwind that and get back to a place where people understand. And sometimes it's impossible. The damage has already been done. So having an objective reader take a look at the disciplinary documentation can be a very valuable practice. Now, don't forget the punchline, and by this we mean what comes next. Where are we? What is the current relationship? So here are some bad punchlines. These are examples of what not to do. Pictures your story should not paint. Disciplinary documentation and meetings are no place for humor. It can be very damaging if an employee believes the employer is making light of a situation when the employee's livelihood is threatened. When I am preparing a supervisor or preparing someone in human resources to have a difficult conversation with an employee, I always make sure to remind them, once you go in that room, nothing is funny. Even if it's something, very inconsequential, it's really important that everyone stay serious and stay on task and is respectful. Because the slightest comment about what someone's wearing, or if you're someone who, or you know, you may have someone who's given to making jokes about, you know, inconsequential things. Those things will absolutely be taken personally when they are in the midst of a disciplinary conversation. So if you see something like this that's actually in the written documentation, get rid of it. Stand up to that manager, stand up to that supervisor, make sure that you get rid of it before it goes to the employee. Because it seems to me that these are examples where someone thought that they were being really witty. And those things just fall really flat in a disciplinary meeting. And here's some more, and yes, they're funny today, but they're not funny and not helpful when they're in actual documentation. So here's how the last line of your disciplinary documentation should come across. It is much better to clearly state that immediate and sustained improvement is required, and that failure to improve will result in further discipline up to and including discharge. It's really important that you don't promise a specific action or limit yourself to a specific time period. I very often see disciplinary documentation or a performance improvement plan where the employee says we need to see immediate and sustained improvement in the next 60 days. Failure to achieve this improvement will result in further discipline up to and including termination. So then we get to the end of that performance improvement plan or that PIP. All the expectations have been met. And so then what do you do on day 61? So the PIP has expired, but you've created a situation where the employee expects that, okay, 60 days, I'm home free. And if something happens after that, what are you going to do? So it's important to make sure that you don't limit yourself to a specific time period, and make clear that misconduct of a different type could also lead to discipline and discharge. And this is frequently done through a disclaimer at the end saying that nothing in the performance improvement plan or nothing in this disciplinary documentation is a promise or a contract of any future employment. Because you want to make sure that they're not looking at it and thinking, oh, well, I'm in trouble because I took a lot of pencils home. As long as I take ballpoint pens next time, I can't be in trouble. That's obviously an exaggerated example, but you don't want to limit yourself by what you say. So now that we have covered the rules, I want to take a few minutes to look at the examples of ineffective and effective documentation. And then we will have still have plenty of time at the end for any questions. So make sure that you send those to Anna as well. Okay, so here we have some disciplinary documentation about someone having a bad attitude. It says this is a written warning for not being a team player and for having a bad attitude. You are being placed on probation for 60 days. Any further incidents during the probationary period will result in termination. So this is a classic bad example of disciplinary documentation. And I'm sure that the reasons why this is bad are just screaming out at you right now. We have two, at least, vague and conclusory labels. First, not a team player, and bad attitude. It's very difficult for anyone to read that and say, all right, I know exactly how I need to improve, and obviously my employer really wants me to improve. These are the worst of the vague and conclusory labels. The probation and the possibility of additional consequences are limited here to a period of just 60 days, and the potential consequences are limited to just one option: termination of employment. And this really takes away the employer's discretion to do anything but discharge this employee if there are any further incidents. This documentation fails to tell the employee what to change fails to tell the employee how to change. And based on this, if the employee wants to be crafty, he or she could say, well, I just need to have a really good attitude, however we can define that, for 60 days. And then I can go right back to having a bad attitude for a while, but I'm still safe per this disciplinary documentation. Furthermore, it sounds like the employee is going to get fired for any unspecified incident during that period. So, you know, one eye roll at a coworker, well, there's an incident of bad attitude, and the only response at the employer's disposal is termination of employment. Now let's look at a much better way to handle this. And you will notice that this is a lot more work too. And I can imagine as an HR professional, if a manager comes to you with that first bad example and you look at that and you think, wow, I have hours of work before me with this manager to try to get from this bad example to something that's going to be helpful. And it is absolutely more work now, but better outcomes and potentially a lot less work later. So it says, I have talked to you several times, including on December 21, 2014 and January 3, 2015, about coworker complaints that you treat them poorly, are difficult to work with, and yell at them. So these are kind of the more conclusory. We're not being too specific here, but then it goes on. Yesterday, January 7, 2015, at about noon, you were involved in a disagreement with a coworker, Bonnie bystander. According to Bonnie, you became upset and raised your voice or yelled at her after she told you that you needed to obtain an officer's signature on checks exceeding $500, even though Bonnie's comment was correct. What I really like about this is that it includes specific dates, and I really love that it includes the year. You know, so often I see documentation and it doesn't include the year. And when you're looking back 2 or 3 years later, it becomes really impossible to put everything on a timeline when you don't have the year it happened. You think you'd always remembered, oh yeah, that was back in 2015, but it becomes much more difficult later on. The coworker complaints are referenced, so that is a specific impact that coworkers are clearly bothered by this because they are making complaints. The specific conduct is highlighted, and then the example that caused the discipline. There's a specific mention of raised voice during the incident, and they include the details about the incident that show that not only was the behavior incorrect no matter what, but the employee was in the wrong. So, and I know that may seem like a small detail. It's like, okay, well, the behavior here is wrong no matter what, because whether or not Bonnie was right or wrong, there's no reason to yell at her. But on down the road, that becomes something that the employee could say, well, I was justified. Here's why I was angry. There was no reason. Bonnie was wrong. Well, you sort of cut that off at the pass by being specific about the situation. And it goes on. So again, yes, this takes a long time. After the disagreement, you came into my office and asked for the rest of the day off. When I asked you what was wrong, you said you were angry with Bonnie because she told you that you needed an officer's signature on a check for $500. You also said to me, and I like this too because it includes quotes, and it's not just being he doesn't just say you were being disrespectful. This documentation makes clear what was disrespectful about it. You don't want to ever speak to, quote, that woman, Bonnie, again. Even having the brackets, like who are we talking about? What are the details here? And that you want and will take direction only from your supervisor. You know, when you see the details, it really brings it to life. It really tells the story, whether you're the primary audience, the employee, or the secondary audience, the employee's mom, judge, jury, Facebook friends. Most people, after seeing the whole story here, are going to look at that and say, wow, this employee was obviously in the wrong. And you don't get that from the bad example. And it goes on to a third slide. Again, really bringing home the fact that this is time consuming. So it says these comments and your behavior toward Bonnie are unacceptable. As a result, you are receiving this written warning. Employees are required to maintain a professional and cooperative working relationship. This includes accepting constructive suggestions and comments from coworkers, communicating with coworkers, and treating coworkers professionally and respectfully. Further performance or discipline issues will result in further discipline, up to and including termination. This documentation makes it clear the behavior is unacceptable, and it defines what is meant by professional and cooperative. That means accepting constructive suggestions and comments from coworkers. And finally, the employee now knows that further issues will result in discipline up to and including termination, and not limited by time here. It doesn't mean that you just have to behave for 60 days and then all is forgiven. No, this is unacceptable. We're not putting a time limit on this. It doesn't go away. Okay, let's move to our second example. And this is about unsafe work practices. And this is again, short, but not a sweet example. It says this written warning is issued because of several incidents over the last 6 months when you have operated your forklift in an extremely unsafe manner. Now, on its face, that seems perfectly reasonable. Yes, this is something that deserves discipline. It seems fine. You scare employees half to death when you drive the forklift near them. You clearly are not paying attention to where you are going. Your forklift driving privileges are being suspended for 30 days. If you exhibit any other unsafe practices over the next year, your employment will be immediately terminated. So just again, this is probably screaming at you all the things that are wrong. So I see the word several. I don't see dates. I don't see numbers in terms of how many times. I see the words extremely and clearly. They don't add anything. They're not factual. We really just want to see the facts. Saying that someone is scared half to death, well, that really depends on the employee, doesn't it? That doesn't tell me about the behavior. So this documentation also limits the time period for additional action to just 1 year. And the employer's hands are tied to terminating employment for any unsafe practice. They have not allowed themselves any discretion here. So even if the employee kind of turns things around and is clearly improving and being 99.9% safe, if another employee comes forward and says, I saw this unsafe practice, you're kind of obligated to terminate employment at that time, and you've removed your discretion. This one is better. It says, I have talked to you several times, but then it goes on to include the dates, including on July 22, 2016, September 3, 2016, and December 1, 2016, about your operation of the forklift in the plant. You have been counseled twice that, and now we have specific behaviors. You drive too fast, and once that you need to sound the horn when approaching blind intersections. Your forklift training has also addressed both of these issues. Yesterday on December 9, 2016 at about 10:30 a.m., you collided with another forklift driven by Cal Careful. Fortunately, neither you nor Cal was injured, but the accident caused $1,500 worth of damage to your forklift, as well as lost productivity because it could not be used the rest of the day. Cal was traumatized and needed to take the rest of the day off. So we have dates, including years. The documentation sets forth the prior conversations about the behavior and states that the employee should know better because there was training. It sets forth the actual unsafe behaviors, driving too fast, not sounding the horn. We have specifics about the most recent incident and the impact of that incident. I really like that this example includes the actual dollar amount, because years later, if you look at that and you say, and there was damage to the forklift, well, that could mean all kinds of things. It could mean that a headlight got broken. It could mean that there's a rip in the seat cushion. Putting the specifics makes things so much more credible. So I think it's important to be specific. Use names, use dates, use amounts. And it's also important to include names. I see a lot of times that people kind of shy away from using names of other employees, but here there's, especially where there's an accident, there's going to be documentation about who was involved in this incident. But it's so much easier if it's also in this memo, because later we may need to talk to witnesses if there's any dispute about this documentation. And it goes on, and it shows that the employee did give a reason or an excuse, but it also shows that the employer looked at that reason, considered it, and decided, yeah, that's not sufficient. And again, it may not come up, but if in the shorter version of this, the bad example of this incident, it doesn't have that. So then he can later say, well, this wasn't my fault. This wasn't my fault at all. But this shows that the employer heard that, considered it, and decided that it doesn't matter. There was still unsafe practices here. And then he says, after talking to both you and Cal about the incident, I have determined it could have been prevented if you were driving slower and sounded the horn. You rear-ended Cal when you rounded a blind corner. In addition, your statements to me show that you have not followed my previous directions to you to slow down and sound the horn. And then it goes on, and it has the further discipline notice, and that it could result in further discipline, including and up to termination of employment. I really appreciate too that, yes, the previous discipline, the previous counseling documentation, it's very possible that that is in the personnel file as well, but the fact that there is this internal reference to those previous ones, it really tells the story, really shows that the employer is being a good actor here, is doing everything they can with the training, with the prior counseling, really doing everything they can to make sure that this forklift driver knows how to be safe. So it's clearly on the driver. Okay. And now we're coming to our final example here. Of course, you cannot have any kind of an HR continuing education without talking about sexual harassment. It just seems to always be the case. So I apologize, but that is our last example here. It says, as you know, on December 1, 2017, the Vice President of Human Resources and I met with you concerning several acts of sexual harassment that had been reported to us. After investigating the complaint, we concluded the allegations were true and that you sexually harassed a coworker by engaging in the following. 1, making extremely inappropriate comments. 2, creating an environment where female employees felt denigrated and threatened. You are hereby notified that any further acts of sexual harassment will result in immediate termination. So we know there's been allegations of sexual harassment, but we have no idea what this employee allegedly did. And you would think that that never happens, but it happens all the time. The first version of disciplinary documentation is vague for various reasons. One, that they just don't know it needs to be specific, or they just decide, well, that it would be inappropriate to be specific in writing. And of course, that's not true. It has to be specific, and you have to challenge your managers and supervisors to answer the tough questions and be detailed. So this also fails to say how the employer concluded the allegations were true, fails to say what the comments were, and fails to say when, where, and who. The employer has also limited itself to termination, but only for further acts of sexual harassment. So, there are lots of ways to harass people. There are lots of ways to act in a discriminatory way. It doesn't have to be based on sex. This makes it seem like, okay, well, you get another first chance, another second chance if your next act of harassment is not based on sex. And I would like to think that reasonableness would prevail, but there is no sense in limiting your action based on something like this. This one, on the other hand, is great. We have dates, we have names, we have specific allegations, and we have quotes. So we have the date of the meeting. And then we have the specifics of what is alleged and the date. So on November 28th, you asked Carrie complainant whether she wanted to have a drink with you after work. You told her that things would be a lot better for her if she socialized more after work with coworkers. So now we have a potential quid pro quo. You know, your terms and conditions of your employment will be better if you come and have a drink with me after work. And then you will have a lot more fun with me than if you go home to that crazy husband of yours. So in addition to the sexual harassment, we have association with potentially somebody with a disability, a mental illness potentially. We're not sure what he means by crazy, but all kinds of inappropriate here. And then it has the second incident. I'd also like to say I'm a gigantic proponent of using bullets, using numbers, making things easy to read and clear. Placed your arm around Carrie's waist, and then how did that homely husband of yours ever catch a hot one like you? You know, as much as we don't like to say things that are inappropriate a second time and repeat them, it's important to do that. So then it says, we interviewed you, and it says what the person admitted to and what they did not admit to. That's very important. And then says, well, I was only joking. And then you said you were sorry and offered to apologize to her. So not just what the employer did, but also what the employee did. And then it kind of goes through how they got to the process. You know, we did an investigation and we've concluded there's sufficient evidence that you engaged in the behavior, and then saying, and what do we think of this? Well, we think it's inappropriate. We will not tolerate it. These are our expectations, and this is what's going to happen if it happens again. And then, of course, here, very key is that it's clear that any retaliation against Carrie for having raised her concerns, or for anyone who participated in this investigation, will also result in further disciplinary action up to and including immediate discharge. I think it's really important, no matter what the discipline is or performance improvement plan or anything like that, to look for situations where you can add the warnings and information about retaliation. So the expectation is clear here. There can be no sexual, discriminatory, or offensive comments. And importantly, this also, as I said, addresses the non-retaliation piece. So then finally, once you have well-written documentation, very important to document the fact that the employee has received it, it was discussed, and the employee understands what could happen next if there is no improvement. And this is a very important step, not to be forgotten. And I think that, when you're having those disciplinary conversations, or if you're counseling a manager on it, make sure they understand the importance of this. And often an employee might say, I can't sign this today, I need to read it, whatever. At least have them, first you want to point out that it's not saying they agree with it. It's not saying that they agree with everything that's in there. It's just saying that they were discussed with me and I understand the potential consequences. If they still refuse to sign it, then the people there who have witnessed the conversation, they should initial and say employee refused to sign, but we are stating that this occurred, it was discussed, and the consequences were discussed with the employee, and then make sure to date it. Because often, you look back at the file or whatever, and you have this blank thing, and there is no evidence at all that this meeting took place, and sometimes it didn't take place. Sometimes the manager just kind of wimps out, never has the discussion, but we still have the documentation of the discipline in the file. So this is sort of the wrap up. You have to make sure that you seal the deal as it happens with disciplinary documentation. So that concludes my my presentation, and then I'd be happy to answer any questions.
We do have just one question, Emily.
Okay.
The question is it appropriate to use quotes from employees in a report?
I think it is appropriate. If the concern is that, well, let's talk about it two ways. If you are quoting the employee who is being disciplined, it is absolutely appropriate, no question. The quoted material is more than likely the offensive comment. It is the reason that sometimes the discipline is taking place. I absolutely think it is appropriate to quote. Only though if you know it's accurate. You know, some of those quotes, if it's hearsay several times over and it was a gigantic game of telephone, well, then you probably want to be a little bit more, more of a summing up. You don't want to use quotes. You want to say, this is what you said, and not use quotes. The other thing I would say is that if the employee used a bad word, right, I would encourage you not to say they used the F word. Just write down what it was. And I know that seems silly, but you really have to avoid any ambiguity. I think it's important to use the actual word that was said. We don't get to be wimps in these jobs. We have to say it like it is. Now, if the situation is that you are wondering whether to quote an employee that is not the person being disciplined, then I think it makes sense to be a little more circumspect. If you're worried at all about retaliation against that employee, it's not necessarily important to say the direct quote. I think that's much more important if it's the person being disciplined.
Perfect. Thank you so much. And thank you for taking the time to present this webinar. We greatly, greatly appreciate it.
Oh, you're welcome. It was my pleasure.
Thanks. So at this time, you should have a slide up that shows our 2020 Federal Library. It's newly released, and just to thank everyone for coming out today, we wanted to give the audience a code for 10% off any purchase. So it's just code webinar 10, and you can take 10% off any purchase at hrsimple.com. And thank you, Emily, so much for that great information. We greatly appreciate it. And have a great rest of your week.